joint report, and it looks like the parties have not completed discovery. Is that correct?
May I, Adam, or?
Yeah, go ahead, Larry.
Yeah, thank you. Thank you. Yes, Your Honor, thank you. Back in April, to answer your question, Your Honor, yes, that's right. Back in April, I was in conversations with Mr. Reich and colleagues about doing a set of depositions. They suggested to me that it would be worth trying to get the case settled, trying to negotiate more and avoid the cost and the expense of that. And they had, I think, a reasonable expectation that settlement was within reach. In other words, that the time might have been well spent trying to do that. And I agreed with that. I spoke thereafter with Adam's, Mr. Reich's colleague, Frances Haynes. We discussed settlement further. I asked her for additional time to try to work with my client to get movement on settlement. Unfortunately, Your Honor, my clients just were not moving in that direction. And I want to say that Mr. Reich and Ms. Haynes were very patient, and I think their motives were correct and in good faith. But unfortunately, we've been unable to settle it, and there's some depositions my clients are insisting that I take. So my suggestion is that we continue this conference to a reasonable date, and I can go back to Mr. Reich, Ms. Haynes, to try to work out what we can agree on as far as depositions.
Thank you, Mr. Felder. Mr. Reich.
Yeah, thank you, Your Honor. I don't disagree with anything that Mr. Felder said. I think he did notice depositions originally back in, I think it was April. We put them on hold to try settlement discussions that ultimately failed. And that he is wanting to proceed with some amount of depositions. I think there's a very minimal amount of discovery from the plaintiffs that we still need to do, mainly just getting some clarification on some discovery responses. So I agree that there's still some discovery left to do. I guess what I would say is, from the plaintiff's perspective, this case has been dragging for a little bit while the parties have been trying mediation and settlement. And so I believe our preference would be to maybe set a trial for a certain amount of time out that we could complete the discovery that we need and get to trial. But with that caveat, I don't disagree with anything that Mr. Felder said.
And thank you, Mr. Reich, and Your Honor. Even though some dates are behind us, I would say to Mr. Reich and his client that if, because of the circumstances, they would like or want a deposition of my client or clients, I'm going to cooperate with them on that completely. Because not to get into it too deeply, but this is a big accounting case in construction, and it's really a cover damages case on 3 very big projects, and it's complicated, or at least my clients feel it's complicated. And if Mr. Reich's clients, as we're doing the depositions, feel that they want a deposition of my client, I'll cooperate fully with that. I understand the desire to get on the trial calendar. We can do that. I'm fine with that. Building into it, these submissions of motions in limine and joint pretrial statement and exhibits and final trial management conference, which takes some time to put out there. I know what my calendar is in that many months, probably going into the future. But if we did set a date today, I would just say I want to make sure that I check with my clients to be confirming that those dates would work for them. And if there was any issue, I would get back immediately, and we would just conveniently find another date. So I have my calendar here, and I'm ready to do that if Mr. Reich would like to, and if the court would also like to do that.
Thank you to both counsel for your time and for your efforts. The court typically doesn't set trial when the parties haven't done haven't finished discovery. I guess my thought would be, and it sounds like the parties have done mediation, which is the other kind of prerequisite. So thank you for that. The parties seem to be without a current scheduling order. So that would
Right.
seem to be maybe the next step. I don't know if the parties can put that together in 14 days.
I can take the lead on that, and I can submit one in the next few days to Mr. Reich. And I think that I don't know what Mr. Reich's schedule is, but I think I have time to submit one very soon, even like a week from today. But if Mr. Reich needs more time, whatever folks want.
Yeah, Your Honor, that's fine with me. I think the 14 days probably makes sense just with
Okay.
schedules and getting back to everybody, but I agree we can file it earlier if we can.
Very well. And the court will require that an amended proposed scheduling order be provided to the court by no later than Friday, September 11th. That's two weeks from today. The court will put the matter on the dismissal calendar for September 11th. And if the court doesn't receive anything by September 11th, the matter may be dismissed. Anything else that the court can assist the parties with at this time?
Your
No,
Honor, I'm sorry, Adam, go ahead.
Oh, no, I was just going to say no and thank you. But Larry, if you have something else.
Yeah, and Your Honor, so in that proposed order, I think what we'll do is we'll have a section at the end that we leave blank that has the court's contact information, and we'll leave the date of the next conference blank so that the court can add that to the order.
That works, and that's that the court's seen that before and is fine with doing that.
Great. Okay, well, thank you. Nothing more from defendants. Thank you.
All right. Anything further, Mr. Reich?
No, thank you, Your Honor.
All right. Thank you very much. A minute entry will issue with that dismissal calendar deadline, and that deadline to submit the joint proposed scheduling order. Unless there's anything else, thanks for your time and efforts, and this matter is adjourned.
Thank you.
Thank you, Your Honor.
Hello, Monica. Can you hear me?
Yes, I can.
Sorry, I just wanted to just confirm